Pack your bags, Cassandra. We're done paying for your mistakes. That's what my father said, standing at the foot of the stairs in our family home in Oak Park, Illinois, his arms crossed and his jaw set like a man who had already made up his mind before anyone walked into the room. I was 23 years old. I was wearing a blue cardigan that still had the University of Chicago Law School crest on the chest pocket. And I stood there, in the entryway of the house where I had grown up, holding a casserole dish I'd brought for Sunday dinner, listening to the words that were supposed to destroy me. My mother sat at the kitchen table behind him, not looking at me. My sister Dana stood just off to my father's left shoulder, a position I would only understand years later as deliberate, with her hands folded in front of her and her mouth pressed into a thin, practiced line that she must have been rehearsing all week. She was 26. She was already a junior associate at the firm where my father had worked for 30 years. She was, in every way that my parents had always measured success, winning. And I was, according to the story she had told them 3 days earlier, expelled. I need you to understand something. I had not been expelled. I had not been asked to leave. I had not failed a single class. I had a 3.7 grade point average at one of the top law schools in the country. I had a summer clerkship lined up with a federal judge in Chicago's Northern District, and I had exactly 2 semesters left before I crossed a stage and held a degree that I had fought for every single day of the 3 years before that moment. None of that was in the room. What was in the room was my sister's voice, which had apparently been in the room 3 days earlier without mine, telling my parents that I had been expelled for academic dishonesty, that I had plagiarized a major research paper, that the school had launched a formal disciplinary proceeding, that I had been too ashamed to tell anyone, and that she had found out through a mutual friend who worked in the registrar's office. Every single word of it was a lie. And when I tried to say so, standing in that entryway with the casserole dish going cold in my hands, my father looked at me with an expression I had never seen on his face before. It wasn't anger. It wasn't hurt. It was something colder than both. It was the expression of a man who had been waiting for confirmation of something he already believed, and who had finally received it. "We always knew," he said, and his voice was even and quiet in a way that made it worse. "We always knew you'd never go as far as your sister." I set the casserole dish down on the entry table. I didn't throw it. I didn't slam it. I set it down with both hands, and I straightened up and I looked at Dana, and she met my eyes for exactly 1 second before looking away. That 1 second was enough. That 1 second told me everything I would spend the next 5 years proving. How does a person end up standing in her childhood home, holding food she made from scratch, being told she's a failure by the 2 people who were supposed to believe in her above anyone else in the world? How does a person reach that exact moment? The casserole dish, the cold entryway, the smell of the roast her mother had made that she would not be invited to stay and eat? I have thought about this question for years. I have thought about it in therapy sessions in a beige office on Michigan Avenue, while lying awake at 2 in the morning in my studio apartment in Wicker Park, while running along the lakefront in the early dark of Chicago November mornings when the wind comes off the water like a physical punishment. And the answer, I've come to understand, is not a single moment. It is a pattern. It is a history. It is something that was built slowly and deliberately over years, and that I only learned to see clearly when I finally stopped looking at it from the inside. My name is Cassandra Lyle. I am now 34 years old. I was raised in Oak Park, Illinois, in a 3-bedroom craftsman house on Euclid Avenue that smelled always of wood smoke, and my mother's lavender hand lotion and the leather of my father's work bag sitting by the door. My father, Robert Lyle, was 61 years old the last time I set foot in that house. He had been a senior partner at a mid-sized corporate law firm in the Loop for 22 years. He was disciplined, precise, fond of golf, and constitutionally incapable of admitting he was wrong about anything. My mother, Helen Lyle, was 58, a former elementary school teacher who had stopped working when Dana was born and never returned to it, and who had learned over the course of her marriage to occupy the space my father left for her, which was not always large. And Dana Michelle Lyle, 3 years older than me, who had always been faster in school and louder at the dinner table and more comfortable in the role of favorite, who had gone to Northwestern for undergrad and then directly into my father's world, law, prestige, a firm where men in good suits told each other they were doing important work. Dana, who had been my best friend until I was about 15, and then became something else. Something I spent years trying to name. I had not followed Dana's path, and that was, I understood early, a quiet source of friction in our household. I had gone to the University of Illinois for undergrad on partial scholarship, I had majored in political science and worked 20 hours a week at a coffee shop near campus to cover the gap between my scholarship and my expenses, because my father had made it clear in my junior year of high school that his financial support was contingent on my attending his preferred list of schools, and I had refused his list. That refusal had a price. I paid it willingly, and I carried it without complaint through 4 years of undergrad, and then I got into Chicago law on merit and a financial aid package that covered 70% of the cost, and I took out loans for the rest, and I did not ask my parents for a single dollar of it. That independence, I see now, was threatening in a way I had not understood at the time. My father respected achievement, but he respected achievement that he could take partial credit for more. Dana's career was his in some way. She worked adjacent to his world. She had taken his advice. She had navigated her path with his guidance, and her success reflected back on him. Mine was mine alone. And mine, as of the spring of my 3rd year at Chicago Law, was pointing somewhere he had not expected. The clerkship with federal judge Margaret Okafor in the Northern District of Illinois was not something that fell into my lap. I had applied in September of my 2nd year, with a writing sample and 3 letters of recommendation, and a personal statement that I rewrote 11 times. I had interviewed in January in a building downtown where the hallways smelled of old carpet and institutional ambition. I had received the offer in March. I had told my parents about it at Easter dinner, and my father had nodded and said something about Judge Okafor's reputation being solid, and Dana had changed the subject to a case she was working on, and that had been the entirety of the celebration. 3 weeks after that Easter dinner, Dana told my parents I had been expelled. I drove home that Sunday because I had planned to tell them about a full-time offer I had received from a litigation boutique in Chicago, 7 other positions pending, which I had not yet disclosed. And instead, I found myself standing in the entryway with a cooling casserole dish and the sentence, "We always knew you'd never go as far as your sister," hanging in the air of my childhood home like smoke. I drove back to my apartment in Wicker Park that night without speaking another word. It was a Sunday in April, and the trees along Augusta Boulevard were just starting to show green, and the air smelled like rain that had not quite arrived yet. I sat in my car outside my building for 40 minutes. I did not cry. I want to be clear about that. I want you to understand that what I felt in that car was not grief. What I felt was something sharp and cold and very, very focused. I felt it settle somewhere behind my sternum like a stone dropped into still water, sinking slowly, disturbing nothing on the surface. I went upstairs. I made tea. I opened my laptop, and I began to write down everything I knew in a document I titled, with no particular drama, Evidence. But to understand what happened over the next 5 years, I have to go further back than that April evening. I have to go back to the year I was 12, because that is where the pattern actually begins, and because patterns are the only thing that make individual cruelties legible. When I was 12, my father got a promotion that changed the texture of our family life in ways we did not fully understand until later. He began working later. He brought the firm home with him in his posture and in the way he ate dinner, quickly and without much conversation, as though the meal were an obligation to be dispatched. Dana, who was 15, had discovered that she could hold his attention by discussing legal concepts she'd been reading about, and their dynamic shifted. She became his companion at the dinner table in a way that left my mother and me occupying a different, quieter tier of the family. I was bookish and opinionated, and not particularly interested in law at 12, which meant I had nothing to offer the conversation my father wanted to have. I was, in the taxonomy of his regard, a younger child who had not yet figured out her value. The message was never stated. It was ambient. It was in the way he asked Dana about her classes with a different quality of attention than he asked me about mine. It was in the way a good college prep book would appear on Dana's desk, but not on mine. It was in the way he'd say, when I brought home a 92 on an exam, "That's good, Cass." And when Dana brought home a 94, it was Dad's eyes lighting up across the dinner table and a 15-minute conversation about what she planned to do with the knowledge. I told myself, through most of my adolescence, that the difference was simply that Dana and my father shared an interest. I told myself it was normal. I told myself that I was reading too much into it. This is the thing about growing up inside a system. You become its most effective defender, because you have the most to lose from seeing it clearly. But there were harder moments that I could not explain away. When I was 16, I applied for a summer writing program at Northwestern. I was accepted. I came home with the acceptance letter in my hand, genuinely excited, and my father looked at it and said, "A writing program. What does that prepare you for?" I said I didn't know yet, that I was still figuring out what I wanted. He handed the letter back and said, "Let me know when you figure it out." He went back to his paper. Dana, who had been accepted to a debate camp that same summer, an application my father had helped her prepare, was taken out to dinner to celebrate. I attended the Northwestern writing program by convincing my mother to help me cover the fee from her household budget without telling my father. My mother was not a cruel woman. She was a woman who had learned to operate in the margins of her husband's attention, and in those margins she had a certain quiet generosity. She slipped me the money in an envelope and said, "Go learn something. Don't tell your father." I did not tell my father. I also did not tell him that the writing program was where I met a professor named David Castillo, who told me, at the end of the 6 weeks, that I had a mind built for argument and that I should consider law. I carried that comment for 4 years like a compass. When I told my father in my junior year of high school that I was thinking about law school, his response was careful and measured and, I understand now, strategically discouraging. He said it was a fine ambition, but that law school admissions were extremely competitive and that I needed to be realistic about my options. He said that the schools he would be willing to support financially were a specific list: DePaul, Loyola, John Marshall, schools that were not what I had in mind. He said he would not fund a Reach school application. He said this as a kind of financial verdict, delivered matter-of-factly, as though it were reasonable rather than controlling. Dana's law school applications 2 years earlier had been funded without conditions. My father had hired a private admissions consultant for her. He had taken a week of vacation to drive her to campus visits. Northwestern Law, her first choice, had come back with a thin envelope, and he had been disappointed but recovered quickly and pivoted to supporting her at DePaul, which he reframed as a good practical choice for someone who planned to practice in Chicago anyway. He had contacts at the firm she eventually joined. Her path had his fingerprints all over it. Mine had nothing of his, by design. His, and eventually, my own. The 4 years of undergrad at U of I passed in a specific quality of independence that I now recognize as one of the most formative stretches of my life, even if it was also one of the most financially precarious. I worked 20 hours a week at the coffee shop. I maintained a 3.8 GPA. I had a social life that was smaller than most of my peers because I had less money and less time, but I had a few friendships that were genuine, and a professor in the political science department, a woman named Dr. Sandra Park, who became something like a mentor. She was 44, originally from Evanston, relentlessly exacting, and the first adult outside my immediate family who seemed to think my particular brand of persistence was a virtue rather than an inconvenience. She wrote my first law school recommendation letter. It was, she told me later, 6 pages long. Chicago Law accepted me with a scholarship package that I still find, looking back at the numbers, almost improbably good. Tuition was over $65,000 a year. My scholarship covered approximately $45,000. I took out loans to cover the remaining 20, and I lived cheaply, a shared apartment in Hyde Park my first year, then a slightly less shared apartment my second year, when I picked up a research assistant position with a professor in the constitutional law clinic that paid $12 an hour and gave me access to resources I couldn't otherwise have afforded. I did not ask my parents for money. I told them about my acceptance. My father said, "Chicago Law, that's impressive." He sounded genuinely surprised. That surprise, I think, was its own kind of insult. At family dinners during my first and second years of law school, I was aware of a shift in the room's energy when my academic progress came up. My father asked fewer discouraging questions than I had expected. My mother began referring to me as my daughter, the law student, to her friends in a way that felt like she was trying on a new outfit. Dana, across from me at the table, was quieter than she used to be. I noticed her watching me sometimes with an expression I couldn't parse. Not warmth, but not hostility either. Something more careful than either. I should have paid more attention to that expression. I was too busy studying. The clerkship application that March of my second year marked the first time I felt, unambiguously and without qualification, that I was going to be fine. The judge's reputation was impeccable. The experience would open doors. I had worked for it in an uninterrupted and solitary way that felt, in retrospect, like the truest and cleanest version of what I was capable of. I got the offer on a Tuesday afternoon. I called Dr. Park, who said, "Without ceremony, I told you." I called my closest friend from law school, a woman named Priya Chandra from Naperville, who took me out for a drink that evening in Hyde Park, and toasted to what she called, with genuine joy, the beginning of the rest of your life. I called my parents. My father was cordial. My mother said she was proud of me. Dana did not call. 3 weeks later, I was standing in the entryway of my childhood home being told I was expelled, and my sister was standing 3 feet behind my father, not looking at me, having told a lie so precise and so well constructed that it had been believed without a single question. The document I titled Evidence, that night in my Wicker Park apartment, started with 6 entries. The date Dana's lie was told, as best I could reconstruct it from my mother's offhand comment when I called her the following morning, asking what had happened. The date I was informed. The exact words my father had used. The name of the person my sister had claimed as her source. A mutual friend who worked in the registrar's office, which I noted immediately was a claim I could verify. The fact that no communication of any kind had come from Chicago Law's administration to me, to my address, or to any phone number associated with my enrollment. And a note to myself that said, "Do not confront yet. Gather first." I want you to understand that the decision not to confront immediately was not passivity. It was not fear. It was the most calculated decision I had ever made in my life up to that point. I was 2 semesters from graduating. I had a federal clerkship starting in August. I had everything to lose from a chaotic, emotional confrontation that my father would narrate as proof of my instability, and everything to gain from patience and precision. I had been raised in a household with a lawyer at the table. I knew what evidence looked like. I knew what it could do. I called the registrar's office on Monday morning. I identified myself and asked whether any disciplinary correspondence had been issued to my file. The answer was no. Nothing. My academic standing was unchanged. No proceeding had been initiated. I asked whether a member of the registrar's staff had disclosed student information to a third party. The woman on the phone, whose name was Patricia, said crisply that student records were confidential under federal law and that no such disclosure would be authorized. I thanked her and made a note. I called Priya that evening and told her what had happened. Priya's reaction was not shock. It was a cold, immediate fury that I still remember as clarifying. She said, "I knew something was off with Dana." She said, "Cass, this is not a family misunderstanding. This is deliberate." She said, "What do you need?" What I needed in that moment was a witness and a confidant who would not counsel me toward forgiveness before the full picture was visible. Priya gave me that without hesitation. The semester ended in May. I graduated in June. My parents did not come to my graduation. Dana did not come. They had been invited. My father sent a card that arrived 4 days after the ceremony with a $50 gift card to a bookstore that I had not shopped at since high school, and no other acknowledgement. My mother texted me a photograph of balloons she had presumably bought and then, I assume, kept in the house. The text said, "We're proud of you, Cass." I looked at it for a long time and then saved it to the evidence document with a timestamp. Dr. Park came to graduation. Priya's entire family came to graduation, and her mother, a woman named Meena who made samosas from scratch for every occasion and cried at ceremonies the way other people cry at funerals, held both my hands at the reception and said, "You should be so proud." I was. I was proud in a way that lived entirely inside me, untethered from anyone's approval, and I remember thinking, standing in the June sunshine outside the law school building with a diploma in my hand, that this was what it felt like to own something completely. The clerkship with Judge Okafor began in August. The judge was 53 years old, precise and demanding and intermittently brilliant, and the experience of working for her was one of the most rigorous and rewarding things I have ever done. I spent a year drafting bench memos, researching circuit splits, sitting in on oral arguments, and learning the architecture of federal litigation from a person who had been doing it at the highest level for 20 years. Judge Okafor did not waste words or time, but she also had a quality of invested attention for her clerks that communicated, without sentimentality, that she believed we were capable of excellent work. That belief was a serious gift. During that year, I continued building the evidence document because what was happening at home did not pause simply because I was busy. My father and Dana had, I learned through a cousin named Marcus who still talked to me, settled into a version of events in which I had been expelled, quietly returned to good standing through some kind of remediation process, and graduated in a state of diminished legitimacy. This version was being circulated at my parents' church, at the country club in Oak Park where my father had been a member for 15 years, among the extended family that gathered at Thanksgiving and Christmas, from which I was, that year and the next, conspicuously absent. The story they were telling required my disappearance to remain coherent. Every year I stayed away and stayed silent and did not publicly correct the record. The story calcified a little more. People who had known me since I was in diapers were now understanding me, in the version my family had constructed. as the daughter who had almost made it and hadn't quite. The black sheep, the cautionary tale. I want you to sit with what that means for a moment. I want you to understand the texture of it. Every Christmas party where someone murmured to someone else. Every Easter where a great-aunt asked my cousin Marcus, whatever happened to Cassandra, I heard she had some trouble at school. Every Sunday sermon my father sat through with a settled conscience, having decided that his version of events was true because it was convenient, and having never made a single phone call to a single person at Chicago Law to verify it. He never called to verify it. I know this for certain because I later obtained verification of exactly that fact. In January of my second year after the clerkship, working now at the litigation boutique in Chicago that had offered me a position during law school, a firm called Harrow & Mills on South Wacker Drive, 9 attorneys, a specialty in commercial litigation with a thread of civil rights work that had drawn me there, I made an appointment with a defamation attorney. His name was Gregory Nowak. He was 47, based in Lincoln Park, a former assistant state's attorney who had transitioned to civil practice 12 years earlier, and who had a reputation, among the attorneys I had spoken to, for being systematic and merciless. I sat in his office on a Tuesday in January, wearing a charcoal suit that I had bought the previous fall, and that made me feel, for reasons I could not fully articulate, prepared. I set a printed version of the evidence document on his desk. At this point, it was 42 pages. It contained dated entries going back 3 years, a reconstruction of the timeline of Dana's disclosure to my parents, a record of the registrar's confirmation that no disciplinary action had occurred, a catalog of the social context in which the false story had been circulated, documentation of several specific instances where I had been demonstrably excluded from family events and professional recommendations as a direct result of the false narrative, and a draft analysis of how Illinois defamation law applied to the specific facts. Gregory Nowak read the first 12 pages in silence. Then he looked up and said, "You prepared this yourself?" "I did," I said. He looked back down at the document. Then he said, "How long did you say this has been going on?" 3 years and 8 months, I said. He was quiet for a moment. Then he said, "Ms. Lyle, this is one of the most organized case files I've seen a client bring in at an initial consultation." I said, "I went to law school." He almost smiled. Almost. We spoke for 2 hours that Tuesday. Gregory explained the elements of defamation under Illinois law with a thoroughness that I appreciated precisely because it was analytical, rather than consoling. He was not interested in my feelings about what had happened, only in the legal architecture of it, which was at that point exactly what I needed. He confirmed that the statement Dana had made to my parents was false, that she had made it as a statement of fact rather than opinion, that it had been communicated to third parties, and that it had caused me demonstrable harm, in the form of damaged family relationships, exclusion from professional recommendations my father might otherwise have provided, social reputational harm within the extended family and community networks in which the false story had circulated, and, potentially, emotional and psychological harm that could be quantified through documentation of therapy costs and career opportunity costs. He also identified something I had not fully articulated in my own analysis, but had been circling around for months. He said, "The question I'd want to pursue is whether the original statement to your parents was the only disclosure, or whether it was followed by additional affirmative steps to amplify and perpetuate the false narrative." I said, "What would that look like?" He said, "Did your sister ever repeat the story directly to anyone outside your parents?" I said, "I believe so. I have one documented account." He said, "We'll want more." Over the next 4 months, I gathered more. Marcus gave me a recorded phone call. He had, on his own initiative and with a directness that surprised me, asked Dana point blank during a phone conversation about what had happened with Cassandra at law school, and she had repeated the expelled narrative to him with specifics. I had a second account from a former family friend named Barbara Whitfield, who had heard the story at a dinner party and found it credible enough to repeat to a mutual contact who eventually repeated it back to me. I had an account from my Aunt Patricia, my father's sister, who lived in Evanston and who had reached out to me the previous year to say that she had heard something troubling and wanted to understand it from my perspective. Patricia had, without my asking, saved text messages in which my father had forwarded her a summary of the situation that directly referenced Dana as his source and repeated the expelled narrative as fact. Gregory reviewed all of this in May and said we were ready to file. What happened next is where I have to slow down, because it matters. Before we filed, I called Priya. We met at a restaurant in Andersonville on a Thursday evening, a small Italian place near her apartment that smelled of garlic and warm bread, and I told her what was about to happen. She listened without interrupting. When I finished, she said, "Are you sure?" Not in a way that suggested I shouldn't do it, but in a way that asked whether I had accounted for all the weight of it. I said, "I've been sure for 3 years. I was just waiting until I had everything." She said, "Okay." Then she said, "I'm with you." I also called Dr. Park, who had by this point retired from U of I and was teaching one course a semester at DePaul. She said without hesitation, "This is exactly the right thing to do, and if you need a character reference or an academic one, I am available." And then, the week before filing, something happened that I had not anticipated, but that transformed the legal landscape of what we were about to do. My cousin Marcus called me on a Tuesday night. It was mid-May, warm already in Chicago, and I was sitting on my apartment balcony in Wicker Park, watching the last of the light go out of the sky when my phone rang. Marcus sounded different. He sounded shaken. He said, "Cass, I need to tell you something." He said, "I've been going back and forth about it for 2 months, and I can't stay quiet anymore." I set my wine glass on the railing and said, "Marcus, tell me." He said, "The year before, Dana told your parents that you'd been expelled. In the spring of that year. Dana came to me and said she was worried about you. She said she'd heard you'd been struggling at Chicago Law. She said she thought you might be in trouble academically." I said, "That's not true." He said, "I know that now." I didn't know it then. I told her I hadn't heard anything like that, and she said, he paused. She said, "Well, I haven't told Mom and Dad yet because I don't want to upset them, but I think it's coming." And I thought she was just being protective. I didn't think she was building a story. I said, "She was building a story." He said, "Yeah." He was quiet for a moment. Then he said, "Cass, I think she had been planning it for a long time." I thanked Marcus and ended the call and sat on the balcony in the May dark for a long time, because what he had just described was not a single reckless lie. What he had described was premeditation. Dana had been laying groundwork months before she made the disclosure to my parents. She had been seeding the possibility of my failure with family members before it happened, creating a context in which the eventual accusation would seem to confirm suspicions that had been carefully planted. This was not a sister who had made a catastrophic, impulsive error in judgment. This was a sister who had looked at my trajectory and decided that it was a threat, and had begun systematically working to neutralize it. I called Gregory the next morning and told him what Marcus had said. Gregory said, "Will he provide a sworn statement?" I said, "I'll ask him." Marcus said yes. We filed the defamation lawsuit on the 4th of June, 1 week before the 5-year anniversary of my law school graduation. The defendants were Dana Michelle Lyle and Robert Lyle. Dana for the original defamatory statement and its subsequent amplification. My father for the active perpetuation of the false narrative. He had repeated the expelled story to at least 4 people we could document, including his sister Patricia's text messages, which under Illinois law made him a secondary publisher of the defamation. The complaint was 47 pages. It asked for compensatory and punitive damages. It named specific incidents, specific dates, specific dollar amounts representing calculated opportunity costs, and it included as an exhibit the sworn statement from Marcus. The day the complaint was filed, Gregory's office served it on Dana at her office downtown and on my father at the Oak Park house. I was at my desk on South Wacker when Gregory called me that afternoon to confirm service. I looked out the window at the Chicago skyline and the river moving gray and slow below it, and I felt, for the first time in 5 years, something loosen in my chest. It was not triumph. It was not satisfaction. It was something quieter and more structural, the sensation of having done a precise and difficult thing correctly. Gregory said, "The clock starts now." I said, "Good." My father called me that evening. I did not answer. He left a voicemail that was, I admit, extraordinary in its construction. It moved through shock, then anger, then a pivot toward concern for me, then a final pass through wounded dignity, all in approximately 4 minutes. He said, "Cassandra, I don't know what you've been told, or who has been filling your head with these ideas, but this is not the way families solve problems." He said, "Whatever happened with your sister, this is not the answer." He said, "I hope you'll call me back so we can talk about this like adults." I saved the voicemail to my evidence document. I labeled it RF1 for Robert First Contact. Dana did not call. Dana, I would later learn from Gregory, had retained her own attorney the following morning, a civil litigation partner at a firm in the Loop, someone with a good reputation and a significant billing rate, which told me that whatever else was true, she had taken this seriously immediately. Over the following weeks, as the legal machinery engaged, I began to understand the shape of what discovery would reveal. Gregory had subpoenaed Dana's personal email accounts and text messages going back 5 years, as well as any communications between Dana and my father during the relevant period, and any communications between Dana and employees of the University of Chicago or Chicago Law. The other side filed motions to limit the scope of discovery, which Gregory systematically opposed and mostly defeated. What came back in discovery over the subsequent months was beyond what I had expected, and I had expected a great deal. Dana's emails from the spring before she told my parents included 3 separate messages to different family members, not Marcus, but a great-aunt in Indianapolis and 2 cousins on my mother's side, in which she raised concerns about my academic standing and suggested that she had heard worrying things. These were the seeding messages that Marcus had described. They were documented. They were dated. They established a pattern of deliberate advance preparation going back at least 7 months before the disclosure to my parents. There was also an email from Dana to my father, sent 2 days before the Sunday dinner where he told me to pack my bags. It was a message that summarized what she planned to tell him and my mother and framed it as a difficult disclosure she was making out of love for the family. She wrote, in language that Gregory would later describe in court filings as self-serving and premeditated, "I think Cass has been hiding this because she's ashamed and doesn't want to let anyone down. I think we need to have a family conversation about next steps and how we can support her." The message made me feel ill in a way I had not anticipated, not because I hadn't understood what she had done, but because of the care with which it had been designed to make her look like the loving, concerned older sister, because of the deliberateness of the staging, because I understood reading it that she had not acted out of impulse or jealousy in a single hot moment. She had acted with calculation, over time, with a defined objective, and she had executed it well enough that it had worked for 5 years. Dana had not wanted me expelled. She had wanted me diminished. She had wanted the story of our family to be legible in a specific way, with her as the successful one, the reliable one, the daughter who had made good choices and whose path reflected her parents' wisdom and support. My success had been disrupting that story. My clerkship, my trajectory, my independence, all of it had been making her narrative harder to sustain, and so she had found the cleanest possible solution. She had told a lie that required no direct harm to me, no visible act of aggression, only a well-placed word in a room I wasn't in, delivered in the voice of a worried sister, and left to metastasize. The metastasis had done exactly what she intended. Gregory deposed Dana in October of that year. The deposition took place in a conference room at his firm in Lincoln Park, with Dana and her attorney present, and a court reporter taking down every word. I was not in the room. Gregory had discussed with me whether I wanted to be there, and I had said no. I had made a decision early in this process that I was not going to allow myself to be in spaces where my reaction to Dana's face could be observed and later characterized as emotionally volatile. I was going to be a name on a complaint. I was going to be the careful, documented, methodical party in this proceeding. Gregory told me afterward that Dana's deposition had been, in his words, productive, by which he meant that she had been unable to account for the emails in a way that was coherent or consistent. She had claimed, through the first hour of the deposition, that she had genuinely believed at the time that I was in academic trouble and that she had acted out of concern. When Gregory presented the emails to the family members, with the seeding language and the framing and the dates, her story began to develop cracks. When he presented the email she had sent to our father 2 days before that Sunday dinner, the cracks became fissures. She could not explain why, if she had been acting out of genuine concern and not deliberate calculation, she had sent a preparatory briefing to our father before the family conversation, rather than simply calling him to talk. She could not explain why she had sent seeding messages to other family members months in advance. She could not identify the mutual friend she had claimed worked in the registrar's office because there was no such person. She had invented that detail as the mechanism of credibility. By the end of the deposition, Dana's attorney was objecting to the majority of Gregory's questions and advising Dana not to answer, which was, Gregory explained to me, itself informative. My father's deposition came 3 weeks later. I was told, secondhand through Marcus, that my father did not take it well. He arrived in the conference room in a good suit and with the manner of a man who had decided he would not be intimidated by procedural formality. He had been in enough depositions to know the format. He believed he could manage it. What he had not prepared for was the documentation of his own role in perpetuating the false narrative. He had told the story to at least 6 people that we had evidence of, the 4 original accounts plus 2 more discovered in Discovery. He had told it at the country club. He had told it to his sister Patricia, who had saved his texts. He had told it to a close friend named Bill Harding, who had mentioned it to his wife, who had mentioned it to a woman who had worked with my mother on a school fundraiser, who had told someone else. The reputational harm I had suffered was not theoretical. It was a network. It was a living, spreading thing that had been growing for 5 years, and my father had been one of its most active nodes. His attorney, a man he had retained from a firm in downtown Chicago that charged significantly more per hour than Gregory, presented a settlement offer in December. The offer was what Gregory called a starting position, a number designed to see whether I would take the path of least resistance and sign something that would let everyone go home. It was $45,000, contingent on a non-disclosure agreement and a joint statement from all parties that the matter had been resolved amicably. I said no. Gregory said, "Are you certain?" I said, "I'm not signing anything that lets them tell a story about amicable resolution. I want the record to reflect what actually happened." He said, "That means we go to trial." I said, "Then we go to trial." I want to tell you about the 3 months between December and the beginning of trial, because they were the most disorienting period of the entire 5 years. Not because I doubted my position, I did not, but because the legal machinery had its own rhythm and requirements that were separate from the emotional narrative of what had happened, and living inside both simultaneously was genuinely difficult. I was still working at Harrow and Mills. I was still billing hours and preparing filings and taking depositions in my own cases. I had explained the lawsuit to the partners at my firm in a direct and factual way at the outset, and they had responded with a professionalism that I deeply appreciated. No excessive curiosity, no concern about optics, just a clear acknowledgement that I was entitled to pursue my legal rights and that the firm would accommodate what was needed. Priya came to Chicago in January and stayed at my apartment for a weekend. We made dinner together on a Friday night. She made dal from scratch and I made bread, and we ate at my small kitchen table and talked for 4 hours. And I remember the warmth of the apartment and the smell of the spices and the quality of the light from the lamp in the corner. And I remember thinking, this is what I protected. This life. This specific and ordinary and entirely mine life. This is what I was protecting when I decided not to accept the first offer. My Aunt Patricia drove in from Evanston 3 weeks before trial to give her witness statement in person. She was 64 years old and had never had a particularly close relationship with my father. They were siblings who tolerated each other at holidays, but she had, over the 5 years of this saga, developed a quiet and genuine fury at what had been done to me. She sat across from Gregory at his conference table and spoke for 40 minutes with the precision of someone who had been turning her own memories over in her hands for a long time, organizing them, making sure they were in order before presenting them. She had saved every text, every one. The trial began on a Tuesday in March, Cook County Circuit Court, Civil Division. A judge named the Honorable Sandra Chen, who was 49 years old and who had, I was told, a reputation for being methodical and intolerant of theatrical lawyering. Gregory seemed pleased by this. He said, "She's going to read every document we put in front of her." I sat at the plaintiff's table and I watched my father and my sister walk into the courtroom. My father was 61 years old, and he had aged in ways that surprised me. The hair whiter than I remembered, the posture slightly less certain, something around his eyes that I identified after a moment as the look of a person who had been telling a story for 5 years and was now, for the first time, in a room where all the evidence was on the table and the story had to hold. It did not hold. Dana's attorney opened with the genuine belief argument, the position that Dana had sincerely believed I was in academic trouble and had shared that belief with family members out of concern, and that sincere belief, even if mistaken, could not constitute defamation under Illinois law. It was a coherent position on paper. Gregory dismantled it over the course of 2 days. He presented the timeline, the seeding emails, 7 months before the disclosure, the preparatory email to my father, 2 days before the disclosure, the invented registrar contact, fabricated, because the truth was that Dana had no source, because there was nothing to source. He presented the registrar's confirmation that no disciplinary action had ever been initiated against me, and the federal law governing confidentiality of student records, which made the claimed source legally impossible. He presented the sworn statement from Marcus, documenting the preemptive seating conversation Dana had conducted with him approximately a year before the disclosure to my parents. Then he called Patricia to the stand. She presented the text messages from my father, in which he had forwarded the false narrative to her in language that was not the language of a man sharing uncertain second-hand information, but of a man stating established fact. He had written, in one text, Cass was expelled from Chicago law last spring. Disciplinary proceeding. She's apparently been hiding it, Dana told us. I'm disappointed, but not entirely surprised. Not entirely surprised. I want you to feel the weight of those 3 words. Not entirely surprised. My father had heard a lie that confirmed a belief he was already carrying, a belief about who I was, about my limits, about the gap between me and his expectations, and he had accepted it without question because it was consistent with the story he had already been telling himself about me for years. He had not needed evidence. He had needed confirmation, and Dana had given it to him. Gregory presented the documented instances of my father repeating the false narrative. 6 confirmed instances, 3 of them with written records. He presented evidence of the professional harm, a letter from a former client of my father's who had mentioned in a separate context that he'd been told by Robert Lyle that his younger daughter had some trouble at school and hadn't quite lived up to expectations, and that as a result, he had not referred legal work to me that he had initially been considering. That lost referral had a calculable value. Gregory had calculated it. He presented my academic record, my clerkship, my current position at Harrow and Mills. He presented the contrast between my documented academic and professional history and the narrative that had been circulating about me for 5 years in the social and professional networks in which I had grown up, and in which my father remained a respected figure. When it was Dana's turn to testify, I watched her on the stand. She was 37 years old, and she was wearing a dark blue suit and her hair was professionally done, and she answered questions in a careful, modulated way that had the quality of something rehearsed. I watched her hands. She kept them very still on the table in front of her, which I recognized, from years of watching trial lawyers, as a technique for projecting calm. Her stillness was performed. I knew this because I knew her hands when she was actually calm. They moved, they gestured, they touched her face. The stillness was work. Gregory walked her through the emails methodically. Why had she sent a message to a family member in Indianapolis 7 months before telling her parents, raising concerns about my academic standing? I said what was true, that I believed her regret was genuine, that I had not reached a place where I could offer the kind of closeness we might once have had, and that if she wanted to rebuild something, slowly, without expectations, without asking me to pretend the intervening years had been different than they were, I was open to that conversation over time. She said she understood. She said she would take whatever I was willing to offer. She said she loved me. I said, I know, Mom. I meant it. I mean it now. And I also mean the distance that I still, to this day, maintain around it. Dana called me once, in the spring of the following year. The call lasted 6 minutes. She said she was sorry. She said she used the word scared, which I noted carefully. She had been scared that I was going to surpass her in a field that she had defined herself by, and that she had acted from a place of fear and smallness, and she knew that wasn't an excuse. She said she had been in therapy for 11 months. She said her therapist had told her that the call was important regardless of how I received it, and I appreciated her including that detail, because it was honest about the context of the apology in a way that made the apology more credible than it would otherwise have been. I said, Dana, I hear you. I said, I am not in a place where I can offer you a relationship right now, and I don't know when or whether I will be. I said, the apology is noted. She said, okay. She said, I'm glad you're okay, Cass. I said, I am. I hung up the phone and sat in my apartment. I had moved by then, from Wicker Park to a 2-bedroom in Lincoln Park, a building with good light and a roof deck that I used on clear evenings, and I sat in the specific silence of a person who has arrived on the other side of something and is taking stock. The apartment was quiet. The afternoon light came through the windows and fell across the hardwood floor in long, warm shapes. The walls were mine. The choices in the room were mine. The silence was mine. I was 34 years old. I had come through something that had started when I was 23, with a casserole dish going cold in my hands, and a sentence I would never go as far as my sister, and I had come through it not despite the things that had been done to me, but, in some structural way, because of them, because they had required me to become the most organized and documented and patient version of myself, and that version had turned out to be capable of things I had not fully understood I was capable of. The clerkship with Judge Okafor had led, in the years since, to a career in litigation that I had built with methodical and uninterrupted intention. I was a fourth-year associate at Harrow and Mills, on track for partnership, with a specialty in civil rights litigation and a commercial practice that gave the firm revenue. I had tried 3 cases to verdict in the past 2 years. I had won 2 of them. The third I had lost by a margin that Gregory, who I had kept in touch with, said reflected a difficult jury rather than defective work, and I had accepted that assessment and moved on. Priya lived in Chicago now, had for 2 years, she had taken a position at a different firm, and we saw each other on average twice a month, and occasionally more, and she remained the most reliable witness to my life and the person most likely to tell me the truth when I needed it. Dr. Park came to dinner at my apartment twice a year, and we argued about constitutional theory with a genuine pleasure that I do not think either of us had expected to develop, but that had grown into something real and sustaining. Patricia and I talked on Sundays. Marcus came to Chicago for a weekend every few months, and we ate too much and talked about everything. I did not see my father. I had not seen him since the day I walked out of the entryway of the Oak Park house, 5 years and several months before this story ends, and I had no plans to change that. He had paid his judgment. He had not called to apologize. He had sent, through Patricia, a message that she described to me diplomatically as an expression of regret for the way things had turned out, which I received and filed and understood for what it was. The apology of a person who regrets consequence rather than action. It was enough that it existed. It was not enough to do anything with. On a Tuesday morning in early April, almost exactly 1 year after the trial, I woke up at 6:30 and made coffee and took it out to the roof deck of my building. The Chicago spring was doing what it does, which is to arrive late and all at once, so that one day the trees are bare, and 2 days later they are suddenly, violently green, and the air has a softness in it that feels like an apology for the 7 months before it. I sat in a chair I had bought at a store on North Halsted, and I drank my coffee, and I looked at the skyline, and I felt something that I want to describe to you as accurately as I can, because it matters. It was not the triumphant feeling I had expected to feel. It was quieter than triumph. It was the feeling of a person who has finally stopped carrying something very heavy and has had enough time since setting it down to understand what it felt like before, by contrast. The weight had been there so long that I had organized my body around it, and without it, I was still learning my own posture. I thought about the document I had titled Evidence, sitting on my laptop in a folder I had not opened in months. 42 pages when I brought it to Gregory's office. 87 pages by the time we filed. 104 pages by the time it was submitted as trial exhibits. A record of 5 years of careful, patient, deliberate work in the service of a truth that everyone in my family had agreed, explicitly or by silence, to pretend was not true. The truth had turned out to be admissible. That still struck me, in certain moments, as almost improbably good news. I thought about the things I knew now that I had not known then. I knew that love without fairness is not love. It is preference dressed up in the language of love, and the difference matters enormously to the person who is not preferred. I knew that silence in the face of injustice within a family is not neutrality. It is a vote, and it has consequences, and the people who cast it have to live with them. I knew that anger, real, specific, directed anger, is not the enemy of clarity, but sometimes its closest ally. I had been angry for 5 years with a focus and consistency that had turned that anger into a legal document, then into a complaint, then into a verdict, then into a judgment that had been collected. The anger had been, in the most literal possible sense, productive. I knew that patience is a form of power that is frequently misread as passivity. My father had read it as passivity. My sister had read it as passivity. They had believed for 5 years that my silence was surrender. They had been wrong. The silence had been full of records and dates and contacts and preparation, and a litigation attorney's phone number saved in my phone under the single word Gregory. I knew that rebuilding your life is not a single event. It is a daily sequence of small, deliberate choices: to answer the phone when Patricia calls, to show up for dinner with Priya, to argue constitutional theory with Dr. Park, to take the commercial litigation case and do it well, to sleep in your own apartment, in your own bed, in a space that is entirely and completely yours. The daily sequence is the life. The moment of verdict is not the destination. The destination is the roof deck on a Tuesday morning in April, with coffee and good light, and the city spread out below, and no one in the world whose opinion of you can touch you in a way that you have not chosen to let it. I learned what my sister was afraid of before I was. I learned it later, from the outside, and with evidence. She was afraid of being surpassed. She was afraid that the family hierarchy she had benefited from her entire life was going to be disrupted by someone who had not benefited from it and who had, for that precise reason, developed tools that she had never needed to develop. She was afraid that the combination of my independence and my ability and my anger was going to do exactly what it eventually did. She was right to be afraid. And what she did in response to that fear was a choice, freely made, that had consequences. I learned that my father loved a story about himself more than he loved his daughters, because when a story was presented to him that confirmed what he had always believed, he received it without question and amplified it without reservation, and lived inside it for 5 years without once calling the school to ask whether it was true. He never called. Not in 5 years. Not when I graduated. Not when I clerked. Not when I made the law firm. She said she was worried. What specific information did she have at that point? She said she had heard things. From whom? She couldn't remember precisely. The registrar contact she had mentioned to her parents? Who was this person? She said it was someone she had known peripherally. A name? She gave a name. Gregory produced a document showing that no person by that name had ever been employed in the registrar's office at the University of Chicago. Dana said she may have misremembered the department. When Gregory put the preparatory email to our father on the screen, the one sent 2 days before the disclosure, with its carefully crafted language about a difficult family conversation and supporting Cass through what was coming, Dana's attorney objected to the characterization of it as premeditated. Judge Chen said, "The document speaks for itself. Counsel, you may continue." I did not look at my father during Dana's testimony. I had made a decision not to watch him watching her. I had decided to use my attention for the things that mattered, and his face in that moment was not one of them. When it was my turn to testify, I spoke for 4 hours over 2 days. I described the dinner, the words, my father's face, Dana's position behind him. I described the years that followed. I described the social network through which the story had spread, with specificity, the church, the country club, the extended family, the professional contact who had withdrawn a referral. I described the psychological impact. I had been in therapy for 3 years, documented, with costs. I described the career costs, documented, with specific instances. I described what I had built and what had been methodically, deliberately, and falsely damaged. I spoke without crying. I am not ashamed to say that this was a choice, that there had been a great deal of crying in private over the previous 5 years, in therapy and alone and occasionally on the phone with Priya, and that none of it belonged in that courtroom. What belonged in that courtroom was precision, clarity, the facts, spoken by someone who had been keeping them in an organized document for 5 years and who knew every single one of them by heart. On the final day of testimony, Dana's attorney made a motion that I had been advised might come, an 11th-hour settlement offer, delivered through the court's mediation process, that arrived the morning of closing arguments. It was higher than the December offer, $120,000, still contingent on non-disclosure. I said no. Gregory said, "You understand that if the jury comes back lower?" I said, "I understand." He said, "All right." The jury deliberated for a day and a half. I worked during that day and a half. I went to my office on South Wacker. I answered emails. I drafted a motion in a commercial case that was unrelated to any of this. And I waited. The call came on a Thursday afternoon at 3:47. Gregory said, "The jury found in your favor. Compensatory damages of $215,000 against Dana. Punitive damages of $75,000. Against your father, joint and several liability for an additional $60,000 in compensatory damages for his role in perpetuating the defamation." I stood at my office window. The river was gray below. The city was enormous and indifferent and full of people who had no idea that on this particular Thursday afternoon, a jury had looked at 5 years of evidence and said, "Yes, it happened. The truth is what you said it was." I thanked Gregory. I called Priya. She cried. I did not. I was past that. But I held the phone to my ear and listened to her cry, and understood that her tears were partly on behalf of the version of me from 5 years ago, who had set down a casserole dish in an entryway and been told she would never go as far as her sister. I thought about her, that version of me, with something that I can only describe as deep, complicated tenderness. She had been right to wait. She had been right to document. She had been right to go to law. The aftermath of the verdict moved through my family like a slow flood. My father retained a post-trial motion attorney and filed a challenge to the punitive damages assessment, which was denied. Dana's attorney filed a notice of appeal. The appeal took 14 months and was resolved against her on the primary issue, with a modest reduction in the punitive component that brought her total liability to $245,000 after accounting for the interest that had accrued. The judgment went to collections when she initially declined to pay on the grounds that she intended to petition the Illinois Supreme Court for review. That petition was denied. The financial consequences for Dana were significant, though not devastating. She was a practicing attorney with a salary that made the judgment painful rather than ruinous. What was more consequential was the exposure. The verdict was a public record. The specific findings, that she had made a false statement of fact, that she had circulated it deliberately and with premeditation, that she had caused documented harm, were a public record. In the legal community in Chicago, where she practiced and where my father had spent his career, public records are read. Within 3 months of the verdict, Dana had been passed over for a promotion that, according to Marcus, she had been expecting, and that her firm's managing partner had verbally signaled was forthcoming. She was not fired. She was not publicly censured. But the promotion did not come, and the conversation around it, which Marcus learned about through a contact at the firm, had included a discussion of the judgment and what it reflected about her character and judgment. Her career continued, but at a different trajectory than it had been on before. My father's consequences were of a different kind. The $60,000 judgment was money he could pay and did eventually, with the help of a check that arrived 6 months after the verdict, with no note accompanying it. What could not be paid was the reputation. His sister Patricia stopped attending his family gatherings. His friend Bill Harding, who had unwittingly helped spread the false narrative, and who had felt, I was told, genuinely disturbed when he understood the full scope of what had happened, quietly withdrew from their friendship. His standing at the country club, where the verdict had been discussed with the thoroughness that social clubs devote to members' legal entanglements, was permanently altered. He remained a member. He remained a partner at his firm. But the particular quality of social respect that had surrounded him, the respect of a man who was seen as fair and principled and sound, had cracks in it that did not close. I know about the cracks, because Patricia told me about them. She and I had developed, through the course of all this, a genuine relationship. Phone calls on Sunday afternoons, occasional lunches in Evanston, a quality of honest conversation that had not been available to me within my immediate family for a very long time. She told me about the country club. She told me about Bill Harding. She told me about the quality of silence that had developed in my father's household, where my mother now moved with a specific kind of careful quietness that Patricia described as the quietness of a woman who knows she should have spoken years ago and is living with that knowledge. My mother. I should tell you about my mother. I had not spoken to Helen Lyle in 4 years when she called me in June, 8 months after the verdict. I was at home on a Saturday morning, on my balcony with coffee, the way I often was on Saturday mornings. The phone rang and I looked at the screen and I sat with it for a moment and then I answered. She said, "Cassandra." I said, "Mom." There was a silence on the line that lasted long enough to be its own statement. She said, "I know I can't." She started over. She said, "I know there's nothing I can say that makes the last 5 years." And she stopped again. Then she said, "I should have called the school myself. I should have asked questions. I knew something wasn't right and I didn't want to know. I want to be careful about how I describe what I felt in that moment, because it was not simple. It was not a warm wave of forgiveness. It was not a wall of continuing rage. It was something more complicated, a grief that I recognized as old and ongoing, the grief of having needed something from a person who had not been able to provide it, the grief of having watched my mother choose the comfort of not knowing over the difficulty of protecting her daughter. I said, "I believe you." She said, I don't expect anything from you, Cass. I just needed to say it." I said, "I know." We spoke for 20 minutes. I did not tell her I forgave her. I did not tell her it was fine. The story was more real to him than the evidence. That is a thing I will not forget, and it is a thing I no longer need to forgive, because I no longer need anything from the person who did it. I learned that the people who were in the room with me when none of the dramatic events were happening, Priya at the Italian restaurant in Andersonville, Dr. Park at my kitchen table, Patricia on Sunday afternoons, Marcus driving to Chicago every couple of months for no reason other than that he wanted to be present. Those people are the architecture of a life, not the verdicts, not the judgments, the people who show up on a Thursday evening when nothing is happening and make dinner with you and tell you the truth. If you are watching this and something in it woke something in you, If there was a moment where you thought, I know what that entryway smells like, I know what it feels like to be the person in the room whose version of events is never the one that gets believed, I want you to hear this directly. The evidence you are keeping matters. The quiet, patient, organized work you are doing matters. The anger that you are carrying and that you are choosing, deliberately, not to spend impulsively matters. It is a resource. Treat it like one. Leave your comment below and tell me where you're watching from. Tell me what landed. Tell me what you're thinking about. And if you know someone who is tolerating something they should have never had to tolerate, share this story. Because sometimes we need to see that the person with the evidence wins. Not always. Not without work. Not without 5 years of a document called evidence on a laptop in Wicker Park. But sometimes. And sometimes is enough to start. Leave your like, subscribe to this channel, and hit the notification bell. Because this is not the only story here about someone who decided to stop accepting less and start building the record. We tell these stories because they are true and because the people who are still in their own entryways, still holding something they brought from scratch, still being told they will never go as far, those people deserve to see that there is a Tuesday morning in April on the other side of all of it. With coffee, with good light, with the city spread out and the trees suddenly and violently green. Tolerance has a limit. Evidence has power, and you have every right to use both.